I'd like to welcome all of you this evening to the annual Law Day presentation here at Iowa State. Law Day has become to mean a witnessing to our existence of a system in which we are ruled by law and not by men, and I think the recent extremes that we saw in Watergate were definite reassurance that we are ruled by law and not men. And our speaker tonight, Dr. Allen Weston from Columbia in New York, I think is a very interesting message to present to us concerning the areas that we're very concerned about having a rule of law rather than one by man. Professor Weston is a professor of public law and government at Columbia University. He has a law degree from Harvard and a PhD in political science from Harvard also. He told me when he was at Harvard he taught in a government class with such notables as Dr. Kissinger, who was on the staff at the time. So I think he has traveled in excellent company. During the past 2 decades, he has specialized in writing about the impact of technology on organizations, citizens, and society. His book, Privacy and Freedom, published in 1967, was a comprehensive study of the social and political functions that privacy serves in a democratic society, and that the dangers to privacy posed by advances in physical, psychological, and data surveillance. From 1969 to 1972, he was director of the project on computer data banks of the National Academy of Sciences, a 3-year study on the effects of computerization on organizational record-keeping and civil liberties. The report on that project, Databanks in the Free Society, was published in 1972. He's worked extensively with the Congress in various areas dealing with privacy and the use of computers in the area. In 1974, he was a principal consultant to the Senate Committee on Governmental Operations under Senator Sam Ervin in drafting the Senate bill that was ultimately enacted as the Federal Privacy Act in 1974. I could read some more things here that we have for his background, but I think probably the thing we'd like to hear is his presentation. And it has a rather interesting title. I'd like you to address yourself to how you came about this title. It's called Privacy, Moving from Whistleblowing to New Rights and Regulations. Dr. Allen Weston.
Some of you may recall in the early 1960s when the civil rights movement was stalled and when a kind of corroding tokenism had begun to be the answer that the Kennedy administration and much of national opinion, liberal opinion, was giving to the demands of blacks for changing the system of segregation that still was locked into the South and much of the middle states, that in 1963, a moment of crisis came in Birmingham, Alabama, when Dr. Martin Luther King Jr., leading the Southern Christian Leadership Conference effort, confronted the police commissioner of Birmingham, a man named Bull Connor, in an epic showdown over peaceful, nonviolent challenges to the segregation in education, in public accommodation facilities, in employment, and in all the areas of police terror that marked Birmingham, Alabama in that year. Birmingham became a symbol in the country for really a confrontation of morality and immorality. And on national television and on the front pages of newspapers throughout the world, there were pictures of the Birmingham police being led by Bull Connor using fire hoses and police dogs against the black and white civil rights groups that were protesting. Birmingham was a kind of spark that set off a wave of protest of this kind in hundreds of cities, changed the whole political condition of the United States, led to the famous March on Washington in August of 1963, and convinced the Kennedy administration that it could in fact sponsor major civil rights legislation in the public accommodation field. And when after the march in Washington, a group of civil rights leaders called on President John F. Kennedy. He sat down with him, and they were reminiscing about how Birmingham had been the start of it all. And he said, we really shouldn't be too hard on good old Bull Connor, because in his own way, he's made a momentous contribution to civil rights. Without him, we never would have been able to get any kind of legislation out of the Congress. My message tonight is that when it comes to privacy, we have a similar situation. Had it not been for Richard Nixon, the unwitting godfather of the Federal Privacy Act of 1974, I couldn't be here this evening suggesting that we're entering a new decade, that from 74 to 1984, we're entering an era of new laws, new rules, new regulations, after a decade from 1964 to 74, which was one of whistleblowing and alarm sounding and of studies and of some effort to define what the nature of the problem of the citizen's right to privacy was in an increasingly technological civilization. And so let me hold Richard Nixon over here for a minute as the unwitting godfather and discuss with you the first decade of the modern American response to privacy. And having explored with you what we learned between 1964 and 1974, I then would like to tell you a little bit about the new laws and actions that are taking place around the country at the state and federal level and in organizational life in the United States, and speculate a bit on where this is taking us, what kinds of new issues and new problems and new opportunities have been presented by the arrival of law after the decade of alarms. I choose 1964 because it was symbolically an interesting year. In that year, Vance Packard, a kind of automatic barometer of whatever the latest pop problem is in America, published a book called The Naked Society. By that time, he had a number of imitators, so there was a book published by a man named Myron Brenton called The Privacy Invaders. As you can see, three-word titles are the sexy way to go about revealing social problems, and so the two books were a symbol that the issue of privacy and the kind of new techniques of invading privacy had by about 1964 surfaced as a new and important growing problem in American society. And by about the mid-1960s, certainly by the time my own book called Privacy and Freedom was published, American society had begun to understand that a host of new techniques and devices had appeared on the American scene that challenged some of the old assumptions and legal traditions for dealing with privacy. That is, if you think for a minute about our legacy historically and constitutionally as far as privacy is concerned, it was built on a relationship between what physically could be done to intrude into people's privacy and therefore ways in which our founding fathers and successive generations of American lawmakers and judges had defined what privacy meant in the American tradition. Since the only way that you could eavesdrop on people and find out what they were saying was to physically lurk under the eaves or try to listen through an open transom or to hide in a room or something like that, the Founding Fathers had made physical entry the key to the Fourth Amendment's guarantee that the right of the people to be secure in their persons, houses, papers, and effects should not be abridged. And before the police could make an entry to search for physical things and seize them or to engage in any kind of listening by microphone or anything like that, they had to have, according to the Constitution, probable cause to believe that a crime had been committed or was about to be committed. They had to go before a magistrate and get a search warrant or an eavesdropping order, as telephone tapping had begun to develop in the late 19th and early 20th century. And our law about listening to people or watching people was based essentially on the idea that if a citizen took reasonable precautions to try to have a private conversation, he or she could do it by locking the doors and closing the windows and not talking too loudly, or by going out into the park or in a rowboat in the middle of a lake and having a conversation in a place where nobody was close enough to overhear. Another aspect of the American tradition was our clear hostility to any kind of effort to penetrate people's minds, which in the 18th and early 19th century context meant things like physical torture or test oaths that required people to confess their religious belief or their political affiliation. And our Constitution and our laws dealt with that kind of existential threat to privacy by forbidding, through the privilege against self-incrimination that was written into the Fifth Amendment to the federal Constitution and comparable provisions in state constitutions, forbade people to be coerced into confessing what they had done or anything about themselves that could incriminate them. And by forbidding the kind of test oaths as to religious affiliation or political loyalty or partisanship, the Constitution forbade this to be a qualification for holding public office or for exercising the franchise, etc. As far as another major area of the right to privacy, when the American Republic was formed, we expressed very clearly our lack of sympathy for the internal passport system that marked the European royal regimes of the 17th and 18th centuries. There was no identification document that Americans had to have with them in order to travel from one place to another in the United States. When you went to an inn or to a boarding house in 18th century America, early 19th century America, there was no official police registration system. And because our mobility of population made it relatively easy for people to move around without documentation, we had a kind of easygoing approach to record keeping and the kind of building up of dossiers about individuals, which, while we never passed any laws about it, there was nothing said in the Constitution about data and record keeping, nevertheless, the hostility to the kind of internal passport police document system that made up the efforts of royal regimes to keep track of the population simply didn't exist in the frontier society or even in the settled cities of the American colonial and early Republican period. So in a way, that was the framework that we had when the 1960s began to make us think twice about privacy. That is, we had a fit between the techniques by which science or technology could intrude into private conversation, private acts, a sense of one's own personal psychological boundaries, or large-scale record-keeping about people. And we had a system of balances between the claim to privacy and the need of society for information or for surveillance over people who were demonstrable in court order type proceedings as criminals or threats to the public peace, that we managed to keep from the days of the framing of the American Constitution until the early part of the 20th century. What the literature of the early 1960s did was to warn Americans that some major changes were taking place in science, technology, and the organization of a complex industrial society that had outrun, or even vaulted over, if you want to think of that as the expression, the legal and existential conditions for protection of privacy. And what the literature suggested was that if you took a look at each one of these three areas that I've suggested, the area of physical surveillance, the area of psychological surveillance, and the area of data surveillance, there were a host of new problems that desperately needed attention from the American public and its lawmakers. In physical surveillance, you may recall, this was the era in which the micro-miniaturized listening and watching devices made their way from electronics and the space program and space medicine and so forth into the world, and television in terms of broadcasting techniques, into the world of police and private eye and Cold War activity. We learned that there were parabolic microphones that could, in fact, make it possible to listen to the conversation of people in the middle of the lake in a rowboat or sitting on a park bench hundreds of yards away from someone who was zooming in on them. We learned that closed-circuit TV made it possible to plant very small television eye devices in rooms or offices and so forth and put people under visual surveillance continuously, or to have automatic camera devices with infrared film and other low-light amplification techniques that made it possible to photograph virtually in the dark. We also learned that it was possible now to take sound from the other side of windows and other kind of vibrating structures, so that given the way our architecture had developed with a kind of glass consciousness of the 50s and 60s, there was very little that would be said in any office building or any modern apartment house or picture window home in which you could claim or expect to have much privacy because of the techniques for taking the sound vibrations from the other side of windows and therefore finding out what people were saying inside. So when it came to physical surveillance, we learned about a host of new techniques being used for business espionage, for political espionage, for police and security investigations that no longer protected the constitutional castle and what went on inside, because now individuals, whether they sought privacy in closed spaces or sought it in very open spaces, were vulnerable to a kind of intrusion which had simply not been feasible or practical or even doable before the new technology of the 1950s and 60s had come along. As in terms of psychological surveillance, we learned about a host of new techniques for finding out what people's emotional states or psychological orientations were. To mention just a few, it was in this period that polygraphing, or the lie detector, underwent a great explosion of use. In two different ways, large American corporations and government agencies began increasingly in the late 50s and early 60s to subject applicants for jobs to polygraph tests, screening them to ask questions about their past, about their sexual and political affiliations, about their habits or other kinds of things that were regarded as job relevant. And because sometimes it was very annoying to have to ask somebody for permission to do that, space technology provided some new sensors. That is, when we began to send astronauts up, we needed devices to find out what their emotional state and what their physical tension was at various points. And so we learned that the pupil dilation of the eye represented as sensitive a measure of changing emotional stress as any of the other more classic measurements, such as the pulse or the heartbeat or the breath or other things that are measured by the classic Keeler polygraph developed in the 1920s. We also learned that the expansion of the blood volume in the limbs was a very good measure of how much somebody was under emotional stress. And so the alarm literature pointed out that a number of government agencies and security offices were beginning to give people interviews in which the picture of George Washington that they were looking at was in fact a hidden camera that was recording the changes in the pupil dilation of their eyes. And they also sat in what was known as the squirm chair, a nice, comfortable-looking, well-upholstered chair, which in fact was a sensitive device that measured the changes in the blood volume in the thighs and in the backside while you sat and were asked questions about various aspects of your loyalty, security, etc. Another area of psychological surveillance that the alarm literature pointed out was the spread of psychological or personality testing in American industry and in government employment. Originally, a number of personality tests like the Minnesota Multiphasic Personality Inventory and many other similar objective tests or psychological measures devised to help people choose voluntarily careers by helping them learn things about their vocational abilities and so forth, or, as the Minnesota test developed with mental patients in Minnesota to try and, again, voluntarily help people to better understand their emotional distress, began to be used by large companies to decide who was a good salesman or not, or by government agencies to decide whether individuals were sufficiently orthodox to be accepted for various kinds of government employment. And what was important from a privacy standpoint, two things, as the alarm literature pointed out, was that first of all, in the name of psychology and of the expertise of the psychologist, people were being asked questions about whether they believed in God, did they believe in the second coming of Christ, who do they think made a greater contribution to American society, Abraham Lincoln or Franklin Roosevelt. They were asked questions, in other words, that never could have been asked directly in terms of religious or political or social values, given American society's classic belief that those were private matters that somebody would not be judged on for employment, especially public employment. But here, in the name of getting up scales of orthodoxy and unorthodoxy or flexibility and rigidity, people were being asked by the government or by large corporations to fill out such personality test inventories and have themselves judged for purposes of employment on that basis. So that was psychological surveillance, a second area in which the 1960s literature warned that we were entering a very strange new era in terms of people being asked openly to reveal themselves in ways they did not understand, or covertly being measured as to whether they were, quote, telling the truth, end quote, when they answered various kinds of questions. And the third area, which I've called data surveillance, was soon understood to be probably the most important of all of these three. That is, with the arrival of the electronic computer and with the data communication systems that were associated with it, large organizations, whether in government or in the business and private sector, had developed an extraordinarily powerful new tool for collecting, storing, processing, and distributing information. So powerful, really, that the kind of limits that existed on collecting and recording and using information about people, personal information, seemed now to have been washed away, because armies of clerks would have been necessary to collect the kinds of information, the volumes of information, that now the computer made available for any organization that had the resources with which to buy a computer, program it, and to use it for the data collection and use purposes of organizations. And with this, you began to have in the early alarm literature the fear that one of the great protections of privacy, the sheer ineffectiveness or the high cost involved in collecting cradle-to-grave information or extraordinarily large amounts of information about the individual, was now being overcome by the arrival of powerful new data processing technology. By the late 1960s, there had been a series of congressional investigations, TV exposés, extensive revelation of how widely wiretapping and eavesdropping, lie detectors, personality tests, and computer data banks had begun to spread in American society. And while this was nothing absolutely unique to the United States, that is, the devices were also being used in England or in France or in Italy, certainly behind the Iron Curtain by the Soviet Union, internally as well as in Cold War competition, almost everybody tipped their hat to the United States as the most advanced user of all of this technology. Somehow there was a superb fit between the American spirit and the use of the technology for the kind of purposes that I've just described. But by the 1960s, the late 1960s, it became clear that American society needed to know more about this technology and how it was being used before it could come up with some sense of what new laws or what new protections would be needed. And so we entered a second phase of this decade, a stage of empirical studies into what was really being done with these new technologies, and the one that came to be the most far-reaching in its implications was the use of the computer in the area of data surveillance. And if you tried to capture what the central issues were that were looked at in these studies, I think there were three fears or three central concerns that clearly marked the American public's concern and the concern of leaders of American opinion. First was the fear that because an organization got a computer, it would inevitably lead that organization, a business, a university, a tax agency, a police department, and so forth, to collect more intrusive, more detailed, more far-reaching information about the individuals that it regulated or serviced than was true of that same organization before it had the advantages of computer technology. So that there was a fear that there would be a broadened scope of data collection, personal data collection about individuals once organizations got computers. A second fear was that as many organizations got computers and it became so easy to have tape-to-tape communication from one computerized organization to another, that there would be more exchange of information about individuals than had been the case previously. And here the fear was that one of the great protections of privacy, which had been the compartmentalization of data about us, that is, we gave information to a credit bureau, we did it willingly in order to get credit. We gave information to a university in order to get an education. We gave information to our doctor or our hospital in order to get medical services. We were required by law to give information to the Internal Revenue Service or to a regulatory agency. And the protection essentially was that we believed that each organization would hold our information for that purpose, and it wouldn't be given up without our consent or without authorization from law to some other data collector and record keeper in American society. And so the second fear about computer technology and privacy was that the ease of data communication through computers and telecommunication systems would lead to our information being circulated throughout society among the record keepers, and that this would be a tremendous limiting of our personal privacy and our group privacy. And third and finally was the fear that as this black box device, the computer, that so few people understood very much about in the 60s, and many today, as the computer was used more and more for record keeping, that this would lead to the creation of more secret files about people that they wouldn't know anything about, or even if they did know something about them, the fear was that they would not know how to deal with that kind of a record system. It wasn't a piece of paper that they could go and contest. It wasn't a 3x5 card or a file drawer. And there was a fear that computerization would lead to the kind of closed record keeping and lack of due process that flew in the face of any sense of individual rights and protection against misuse of information. Not just in the United States, but in many of the parliamentary democracies of the West, between about 1969 and 1972, there were studies done to take some assessment of this computer issue and privacy and these three basic fears. In the United States, there were two studies, one done under the auspices of the National Academy of Sciences, which I directed, another done by an advisory committee appointed by Secretary of Health, Education, and Welfare, Elliot Richardson, both of which tried to see how computers were really being used and what the issues were. In Canada, there was a similar study done under the auspices of the Department of Communication and Justice. In Britain, there was a royal commission appointed under Sir Kenneth Younger that did a similar study. In Sweden, in West Germany, in Norway, in at least a dozen countries, studies were done trying to respond to these basic fears that the population had, that something was changing in a fundamental way, with the computer as the most important of the moving elements in this change in balance of information about people and the power of government and large private organizations. And by about 1972-73, the verdict of these studies began to come in. And one of the things that was uniform in all the studies that I've just briefly mentioned, examples of other countries, was that on a number of the major fears, the verdict was, in effect, it's not happening yet. Let me go back to the three fears that I mentioned and just explain briefly what was found about them. First of all, as far as organizations collecting more information because they got a computer, more intrusive, broader collection of information about people, it was found that this, in fact, had not been the trend as a result just of organizations getting a computer. The reason was, or several reasons existed for this, it's very expensive to automate information, and so when organizations computerize a particular file, they tend to choose the record system that is most frequently used, that contains the most objective type of information that can be coded and reduced down to computer-readable form, and to look for information that is, in a sense, the information that is going to help an organization to do its job most effectively in relationship to the individuals that it has as its clients or customers or its subjects. And therefore, in most organizations, when they got computers, they didn't computerize everything. They selected a segment of their records they already kept about people, automated only that, and in fact, in many instances, wound up putting just a portion of what they had traditionally collected onto the computer for use. And in many organizations, indeed, it was found that when the committees made up of the specialists in particular areas and in computer technology went to automate, they learned that there was a lot of information they'd been collecting for a long time that probably wasn't even being used, and so they didn't collect it anymore. That is, they would say, well, why do we need this piece of information for our purpose as a bank or an insurance company or a police department? And the answer was, well, the beloved founder of the organization, or good old Chief so-and-so 25 or 50 years ago, thought that was terribly important for us to have, but of course nobody uses it, and they often found that they simply had no reason to put the high investment into automating that information. So that, in fact, it is not true in the great majority of organizations, as the studies found, that simply getting a computer led organizations to collect more far-reaching information about individuals. The same kind of conclusion was reached about the second fear, that is, the fear that just because organizations got computers, this would lead them to exchange information from organization to organization. What the studies found was that organizations, when they exchange information, do it according to very strongly developed patterns in a particular industry or a particular area of government, which define who they'll share with and who they won't. And it has to do with police trusting other policemen, universities exchanging information with other educational institutions, credit bureaus giving information to credit grantors, certainly a kind of information buddy system that says you give me your information, we'll give you our information, but one in which that kind of data sharing had existed in most of these areas for 50, 75 years, long before the computer came along, and that because information is in fact a scarce resource and is a valuable commodity, just having a computer did not lead organizations to give information to the kinds of groups or the kinds of organizations that they had not shared with before. And that where the real privacy problems came up was when American society had not set clear enough rules about who they wanted information shared with and how it should be held confidential. And therefore, studying the way computers were being used, it was discovered that the computers were not leading to new patterns of data sharing of a different kind than had existed previously. There are about 2,200 local retail credit bureaus in the United States, loosely affiliated in an organization called the Associated Credit Bureaus of America. And these are the so-called mom-and-pop, small-scale local credit bureaus. They operated largely by mail, by facsimile transmission, or by telephone exchange of information. And as somebody would leave one community and go to another and ask for credit, they would write off and get their credit record where they'd been before. Several organizations developed regional computerized credit reporting systems, notably firms like TRW Credit Data Corporation and a few other regional systems. They put all of the records they had on individuals into central single tape storage. Now, if you came to them and said, look, I've got a problem, I think you've got wrong information about me, I'm not the person that had a judgment against him in the court, or I'm not involved in a divorce proceeding, or whatever it is that's hurting my credit, or I don't owe money to the bank, they could show you immediately a printout of your record. If you contest it, it can be looked at. And if it's an error, then they can show you that they have corrected your credit report in the computer system, and everywhere that your report is disseminated, anywhere in the country, it will now come out correctly. Whereas when you deal with manual records and several thousand local credit bureaus, you really could never be sure in that paper-oriented system whether, in fact, if your credit report had been improperly sent out, whether somebody wasn't still circulating your mistaken report because there was no easy way to get a national system-wide correction or verification of what it was that was being reported about you. So that by about 1972-73, there'd been, through the studies that I've mentioned, one important verdict, or one half of the verdict, which was that some of the kind of 1984 Buck Rogers type judgments that were being reached by the early alarm sounders about what computers automatically did in organizational record keeping about people had proved to be erroneous, that they had simply not understood the way in which computers would be used, how organizations could use them, or the kind of world of record keeping in which the computer was by no means so powerful as to transform, but rather was just another tool. But there was another half to the verdict of these studies. The other half said that the computer had arrived in the late 50s and the 1960s at a moment when American society was undergoing an absolutely profound change in two aspects: in the standards by which it wanted people judged for rights and benefits and opportunities in the society, and in its theory about how open and democratic organizations ought to be in making those judgments. Let me just briefly explain those. On the first, the standards, think back 10 years, 15 years ago, about what record systems had about what race a person had, what religion, what their sexual proclivities were, what their political ideology was, if they'd ever been arrested for a demonstration or for something of that kind, whether the individual wore his or her hair properly and dressed properly and so forth. In short, the record systems of the 1940s and 50s embodied a set of criteria about a good employee, a good political figure, a good credit risk, a good insurance risk, which American society in the 1960s and early 70s had turned fundamentally away from. Not just in terms of it being thought different morally, but in fact our law said that now you cannot even ask questions about race or sex or religion or other aspects of what was being increasingly regarded as the private domain on which people should not be judged officially for government purposes or for many employment and other opportunities in the society. Yet here are all these records accumulated about people which had such information in them historically, and in which many organizations were still asking such kinds of questions or using information in the records to make judgments about people. So that essentially what you had was a system of record keeping based upon standards which American society was, if not some of them clearly changing, at least there was a deep social debate about what uses should be made of such types of information. I'll just give you a quick example. Life insurance companies have long had a practice of putting a special high rating on persons who are homosexuals. They base this on their actuarial studies that homosexuals have earlier mortality rates and a higher suicide rate than heterosexuals. And of course that is true given the kind of social pressure against homosexuals in the last 50, 75 years or more in the United States and elsewhere, so that it was true, quote unquote, as a fact, quote unquote, that homosexuals represented a greater risk for life insurance companies, especially in large policies, than heterosexuals. And so the practice developed over the last 50, 75 years of doing sex investigations of all persons who apply for life insurance policies above a very small amount. And that means that the investigators for various kinds of insurance inspection firms go out and investigate all of our sex lives because they have to show that we're heterosexuals to qualify just as much as they try to ferret out who the homosexuals are that are applying for large life insurance policies. Now, I don't think American society will much longer accept that as permissible behavior by life insurance companies and their investigators, essentially because we'll treat that, I think we will soon, like any other area in which we decide that in the interest of not having all of our sex lives investigated by $6,000 and $7,000 a year gumshoes for commercial inspection agencies, that we'll decide that we'll socialize that risk. That is, we'll tell life insurance companies that they have to charge a sufficient premium, that they spread the risk that even in the future with social pressures and conditions different, they're not going to be able to charge a rate and a half for homosexuals who get life insurance than for heterosexuals. But the problem is that giant record systems and investigative mechanisms were being based on the idea that it was acceptable for, and still is, for life insurance companies to engage in that kind of conduct. The other aspect that the studies found that was dangerous and frightening about some of the computerized record systems and manual record systems was that in so many areas people simply did not know what was going on, and it had grown up as customary that that was acceptable. Again, just let me give you an example. For the first 75 years or so of credit reporting in the United States, the law in America was that a report of a credit bureau or a pre-insurance or pre-employment agency was a private communication between that business service and its clients, who were banks, department stores, auto dealers, and so forth. You, as the subject of the credit report, had no right to know it was being drawn, to know what was in it, to challenge the accuracy, and so forth. And in fact, the credit grantors who signed a contract with the credit reporting agencies swore never to tell you that a report was being drawn, never to give you access to it. And if you did, as a credit grantor, show somebody the report that you'd bought from the credit reporting agency, and it was absolutely wrong, it was so inaccurate that the person could sue and recover damages for malicious or willful error on the part of the credit reporting agency, you as the credit grantor by contract agreed that you would have to pay the damages of the credit reporting agency because you had let the cat out of the bag and let the individual learn the injury that was being done to him or her. Now clearly, once that was learned in the late 60s, early 70s, that was intolerable, especially in a credit-dominated society with the American middle class, which is quick to know how to make law to protect it, aware that so much of the opportunities that people wanted to have in credit, insurance, employment, was being run with such a secret record system. And so essentially what these studies concluded was that no, the computer was not some kind of giant data monster like the Sorcerer's Apprentice, that when you plugged it in, it sort of poured out buckets of data and shared it with everybody, and you couldn't turn off the machine. That was simply a kind of self-frightening and apocalyptic vision that some of the early warners had misunderstood. But they also said that the computer was leading to faster movement of information, larger networks of data sharing, to the creation of giant record systems at a time when American society was moving into a whole rethinking of how people should be judged and the procedures on which they should be judged. This carries us to about 73, 74, and now we come back to Richard Nixon. Because if it would have stopped there, if Richard Nixon had been a good constitutional president, if we would have had a law and order regime that would have fulfilled the silent majority image of the Nixon administration, I don't think that I'd be up here able to report to you that there's been some very important and epic-making legislation in the privacy field that has recently been enacted. Because what it took to move from the second stage, which was a better appreciation of the true dimensions of technology and privacy, was some sense that it could happen here, that there could be serious misuse of the resources of data and of the new technology of computers and telecommunication systems by men who would not respect traditional boundaries of morality and of legal norms. And that's where Richard Nixon came in. Because obviously what the Watergate hearings proved to the average American was that, as Sinclair Lewis's novel put it, it can happen here. Because what we saw was a president who was willing to send his agents to break into a psychiatrist's office to get the psychiatric files on a critic of the administration, who had called on the Internal Revenue Service to produce income tax information on critics from the press and television and political opponents of the Nixon administration, an administration which had been willing to develop a White House enemies list and to promise to use the power over regulation of radio stations and licensing of television stations and tax audits against critics of the Nixon administration, which was willing to send its agents in to put telephone recording devices into the suite of the Democratic Party in the Watergate by good old-fashioned breaking and entering, but nevertheless the technology of telephone monitoring and hidden microphones, and clearly an administration which was willing to use every technique, old-fashioned or super modern, to engage in a surveillance and punishment over critics in the media, in the minority group populations, and in the party setting, which made it clear that if no restraints could effectively be built around record-keeping and personal files, that in the hands of another Nixon 5 years from now, 10 years from now, could really spell disaster for any kind of civil liberties and protection of individual privacy in the country, political dissent, political opposition, and so forth. And there were many people who said, as they thought about the issue, you know, I wouldn't be so damn comfortable if Lyndon Johnson were there doing some of those things too, remembering that there was a certain vengeful side of LBJ and a certain delight that he got in having J. Edgar Hoover play recordings for him and give him information that the FBI had collected about political opponents, Dr. Martin Luther King Jr. and others that Lyndon Johnson wanted to know about in terms of their personal activities. And so what you got from Watergate really was the last push that was needed to convince enough of the public, and certainly the legislators, that the time had come to take some action. And so now we enter the modern period, or the decade that we're just beginning. And there are two trends that I think are the outcome of what I've been describing to you. First, Congress passed in December of 1974, and President Ford signed just after the new year, what I think is one of the most promising pieces of civil rights and citizens' rights legislation in our history, a statute called the Federal Privacy Act of 1974. It's so far been much underreported in the press, and I think that the fact that nobody hears much about it is really quite surprising. It doesn't go into effect until September of 1975, and maybe we've got some time to get the word out about it. But essentially what the statute does is this. It creates a code of fair information practices that all federal agencies must follow in their handling of personal data about individuals. And what it does is respond, I think, superbly to the dilemmas and the hard choices that are involved in balancing the right to privacy against the government's need to know information and to protect people in society. What it says principally is this, that first of all, anytime the government asks you for information with forms, questionnaires, and so forth, you must be told in the future that the authority under which the government requests the information from you, whether the information is voluntary or compulsory for you to furnish, and the uses that will be made of the information. And unless you're told that, you can just send it back to the government and say, thanks, I do not choose to complete your form. The Privacy Act also says that you have a right, with a few exceptions, which I could go into in a minute, you have a right to see any record that's maintained about you by any federal agency, bureau, or department, and reasonable opportunities must be given to you to inspect your record, to challenge its accuracy, to have the government reconfirm or reinvestigate the information that's there, and to have it corrected if you can show that it's wrong. More broadly, the statute provides that federal agencies must only collect information which is, and the words of the statute are, relevant and necessary to the lawful function of the agency. And explicitly, all federal agencies are forbidden to collect information about the exercise of First Amendment rights of speech, press, association, and religion on the part of Americans, unless directly authorized by law. That is, there are some circumstances in which the FBI is by law allowed to make inquiries for personnel security purposes, for example, and clearances, so that if there's a legal right to make an inquiry, it can be done. But unless there is that kind of clearly given legal right, the Privacy Act of '74 forbids the collection of information. A good example of what it would forbid was the way that Army intelligence between 1967 and 1970 collected thousands of records about anti-war protesters, black militant groups, and others in the name of getting the Army ready to deal with problems of civil disorder in the cities as a reaction to the riots in Detroit, Newark, so forth, but in a function that, as I think the universal verdict of Congress and the press and of public opinion was a function absolutely wrong for the American military to be performing in a society that has a rigid separation between civilian and military functions. In addition, the Federal Privacy Act provides that once a year, every federal agency must publish in the Federal Register a public notice of every record system that it maintains, indicating the nature of the system, what information is collected, on whom the information is collected, with whom it's shared, what rights of access there are to it for individuals, its security protection for the system, etc. Most important of all, the Federal Privacy Act of '74 gives individuals a right to go to federal court in both civil and criminal actions to get a judicial verdict as to whether agencies are violating the standards and procedures of the Act. It provides that if you're successful and show that federal officials have been violating the Act, you not only will get your lawyer's fees paid, which is always a damn fine incentive for litigation, putting the organized bar of America behind the effective enforcement of the Act, but also there are liquidated damages that are awarded, and so there's a good system making it worth your time and effort to try to protect your privacy against the federal agencies that may violate it. And finally, the Act makes it a criminal offense, subject to criminal prosecution for any federal agencies to knowingly violate any of the provisions of the Act. So you have a criminal sanction at the heart of the statute. Now, there are a few exemptions, fairly controversial ones that were fought over. There's an exemption for the CIA. There's an exemption for intelligence activities of law enforcement agencies, but not their arrest record systems or their case files, but rather their intelligence activities, and for some personnel investigative activities of the Civil Service Commission. But I would estimate that well over 98% of the record keeping by federal agencies is covered by the statute. And so we have in place, first of all, a major federal statute going into effect in September of 1975 that I think represents a new handle for protecting the right to privacy against intrusive, inaccurate, improper record keeping and use of personal data by any federal agency. The other trend that's important to note is at the state level. Between 1973, when Watergate surfaced at its height, and 1974, about half of the American states have passed important privacy legislation covering the activities of state and local government agencies and some of the private sector's activities as well. For example, 3 states have set up similar codes of fair information practices for state government to the provisions that I described for the Federal Privacy Act in 1974, Minnesota, Utah, and Massachusetts. And in quite a number of states, similar legislation is pending that would give you the same rights vis-a-vis local and state government agencies. 8 states have created study commissions that are to report back to the state legislatures what legislation is needed to protect privacy in those states, and I think those study commissions will probably lead to important legislation of the kind that I've been describing. 18 states have written particular privacy protections dealing with school records or dealing with medical records or credit reporting, etc. And I would think that by, say, 1976, I'd be very surprised if a majority of the American states, with the momentum that is now moving, will not have passed similar basic privacy protection statutes covering activities of government and some private organizations. There are now pending in Congress in at least 4 or 5 areas major particular privacy statutes or bills that I think have a very good chance of passage and will continue the momentum in Congress. I should mention that in 1970, Congress did pass a very important statute called the Fair Credit Reporting Act that corrected the situation that I described to you earlier. It provides that if you're denied credit or insurance or employment and a commercial reporting agency was used to do a report about you, you must be told that that was the case. You must be told the name and the address of the agency. You're given by federal law a right to go and be told about the contents of your report. You can require that they reinvestigate. If they think it's accurate and you still don't, the statute gives you a right to put a statement of your own, up to 500 words, into the record, and that must be disseminated by the agency to anybody that it gives their version of the events to. So if you say that you ordered a refrigerator from the local appliance store and you stipulated that it had to open from right to left, and they sent you a refrigerator that only opened from left to right, and you refused to pay, and that's the reason why you haven't paid your debt, that must be put into your record, and they can't say that you have refused to pay the Ace Appliance Company without giving your version of what the dispute is as part of the report. I also should mention, just by way of reminding you, that Congress last year also passed the so-called Buckley Amendment, which provides that school and college records must be held confidential and cannot be disseminated to employers or to other agencies without your knowledge and consent, and giving students in college and parents for children under age a right of access to all the records that are maintained by the schools in files about them. At the present time in Congress, you have pending, as I mentioned, a number of bills that I think will become law soon. There are bills to regulate criminal justice information systems that are operated by computers. There's a bill to provide better privacy for all of our bank records, because today, if a law enforcement agency goes to a bank and says, let's see all your checks on John Smith, and checks, of course, indicate what political contributions you've made and what subscriptions you have and tell a great deal about you, a bank can comply without ever telling you that such a request has been made by a local police department, by the FBI, by the Internal Revenue Service, whoever comes. The bills that are pending in Congress would require that you be notified by the bank before they surrender your checks, and if you believe that that's an improper subpoena, you have then the right to go to court and in a judicial proceeding contest the validity of the subpoena or its scope or any aspect about it before your checks will be given up. There are bills, for example, to protect health records, and especially as we move into a time when national health insurance is likely to be voted by, if not this Congress, probably the next one, it becomes critical to define what rights of privacy will exist in the kind of national record systems that will be developed about us in order to provide for national payment of our medical and mental health kinds of services. Drawing back then and looking at the story as a whole, is it a hopeful one? Does it suggest that we've turned the corner on the problem and that now we have some excellent tools with which to work? I guess my own reaction would be a little yes, a little no. I think, first of all, we've got a better picture of what the nature of the problem is than we did when people had a kind of blame it on the computer reaction. Because the computer really doesn't do anything. It's not like the devil who makes us do anything. What's done with computers is what we do with them, and therefore returning the consciousness of policymakers and the public to the fact that it's our organizational leaders and ourselves as the society that's responsible for what is done with computerized information and record systems is the beginning of any sensible approach. I think the concept of fair information practices, as the Federal Privacy Act and as the state counterparts have identified, is a very thoughtful and useful, workable concept, because it builds on the long-standing American administrative and constitutional law traditions of other kinds of fair and unfair practices, unfair labor practices, antitrust violations that are unfair in terms of unfair competition, the concepts of defining what is acceptable and unacceptable practice in a given area and looking to the regulatory agency approach to try to make good sense of it for American constitutional tradition. And by giving individuals the right to sue and to pursue their own rights, you have, I think, a much better system than some of the other Western countries have adopted. For example, Sweden in 1973 passed a National Data Protection Act, which sets up a 9-member data protection board with power to license every computerized file set up in the country by private business, by private organizations, and by government as well. And if they don't license it, you can't manage it, you can't run it in Sweden. And they have the power to require that you give them full accounts of what you're collecting and how it's shared. They have the right to audit and inspect your system to see that it's got the proper security protections and so forth. Now, I've been to Sweden, and I know Swedish law and government rather well. I think it's a fine system for the 8 million people that live in Sweden, which has the Napoleonic Code tradition, which has extremely high trust in government administrators, and in which the tradition of the civil service and of independent judges and administrators is really very strong. I think that would be a disaster for the United States, because I think if we had such a powerful data protection commission, rather than lodging the power in individual citizens to protect themselves through the courts, you have to imagine that such a system would have had, say in 1973, John Dean as its chairman and Charles Colson as its general counsel, and the Data Protection Board would have had all the locks and keys into what IRS computers had and what the National Institutes of Health had and what the Social Security Administration had on people. And the question would only have been how fast they could have gotten all the information together for Richard Nixon, rather than ensuring any kind of effective protection for us. So I suppose that my optimism is really a little greater than my pessimism. I think we have developed a new set of concepts and a set of, for us in the United States, rather workable tools to try to deal with the problem of balancing the claims to privacy against the obvious needs for information to manage a complex and technically oriented society. Ultimately, I think it depends a lot on whether we as individuals really regard privacy as the kind of value that we're willing to go to the mat for. And therefore, there's a certain kind of lovely symbolism in the fact that the Federal Privacy Act will come into effect in September of 1975, just as we move into the celebration of the bicentennial year. Because, as I think we always need some reminding when the bicentennial gets hucksterized as much as it already is being done, that we fought the American Revolution in one important part because we were so outraged at the writs of assistance and general warrants that were used by the agents of the Crown to intrude into the privacy of American homes, to get correspondence and letters and papers, that we resented the quartering of British troops in private homes and the intrusion into privacy that was involved there, and that the speech of James Otis against the writs of assistance was one of the great moving acts that helped precipitate us toward a Declaration of Independence. Therefore, I like to think that we now have the approach to rekindling the kind of revolutionary spirit in defense of personal privacy that marked, in our bicentennial sense, the way in which this country first understood how precious privacy was, how important it was as a fundamental value without which other aspects of our constitutional rights, of our Bill of Rights, couldn't come into play. That is, you really cannot have a First Amendment with its protection of the right to speak, the right to publish, the right to associate, the rights of religious freedom, if somebody else can turn you on without your consent, through eavesdropping, through psychological testing, through enormous detailed record keeping and dossiers, because it robs each one of us of our capacity to decide.